Hello, I want to welcome our viewers across the United States and around the world. I am attorney Alan Edmunds, and you're in the National Security Clearance Situation Room of the Edmunds Law Firm. I founded this law firm over 41 years ago, and we are proud to help people around the globe, both active duty military and civilian, as well as federal employees, fight to keep their national security clearances. As many of you know, this is a time when the federal government is coming after security clearance holders for a number of reasons. And today, because of your emails and phone calls, I'm going to talk about one of the most popular reasons that the government comes against your clearance. And in my hand here is the directive 5220.6. It's the new directive, and I suggest that you get it. You can get it off the internet. It was modified June 8th, 2017, and it does contain some important changes, so I recommend that you get the directive. The area that I want to talk about today is Guideline E, which is personal conduct. Personal conduct deals with questionable behavior, lack of candor, dishonesty when you fill out the SF-86, or unwillingness to comply with rules. It's a section that the government uses because it's so easy for the government to prove it at a hearing. And I always see Guideline E, personal conduct allegations, together with Guideline F, for financial considerations, when a person fails to declare certain debts that are delinquent, or past due taxes or tax liens, and Guideline B, foreign influence, where applicants fail to include relatives, property that they may hold in another country, and passports. So Guideline E is very, very important. And fortunately for you, while the government uses it frequently, I have been very successful defeating the government when they bring these Guideline E allegations, if there is sufficient mitigation that my team of experts at the Edmunds Law Firm, in conjunction with your help, compiles a trial notebook that enables the administrative judge to rule in your favor on Guideline E cases. So Guideline E, which is paragraph 13 in the directive, says that they are concerned about conduct involving questionable judgment, lack of candor, dishonesty, or unwillingness to comply with rules. And they believe that that type of behavior can raise questions about an individual's reliability for trustworthiness. Let's go back a step and orient ourselves to what the government is saying about you and other people when they file what's called a statement of reasons, the first level of appeal. And they file this document. They're saying, in essence, that you're a risk to national security and that you're untrustworthy. Many people make the mistake of answering the statement of reasons by themselves, and then they're perplexed when the government doesn't accept their response. The statement of reasons is a very important document, and it's the basis of your whole case. So if you file a statement of reasons and you're unsuccessful, you should then request a personal appearance or a hearing. But know this, that what you put down in the statement of reasons is going to continue with you through the entire process at the hearing and even the appeal beyond the hearing, because it becomes part of your record. So what you say and how you say it is extremely important. I have clients that are scientists, computer science experts, physicists, doctors, and they're brilliant. But when it comes to responding to an SOR, they aren't brilliant. It's a case of first impression, and they often make their case far worse, unintentionally, by answering the SOR themselves. So if you get an SOR, call me, 800-481-2526, or go to our websites, nationalsecurityclearances.com, and read all the cases that my staff and I have won over the last 40 years. As you know, I have offices in Washington, D.C., Raleigh, North Carolina, Florida, and California, and our attorneys travel across the country. And as many of you know that are deployed, we represent a huge number of linguists and military personnel deployed throughout the Middle East, Germany, and in Asia. There are mitigating factors under Guideline E. There's aggravating factors, which is paragraph 16, and the government begins that section by saying conditions that could raise a security clearance. And again, we get to deliberate omissions and concealment in the SF-86. The second area that could raise a concern are deliberately providing false or misleading information. And I see this a lot. What happens? The individual filling out the SF-86 simply forgets to put certain information down on the SF-86. Some people are given a very short period of time by their commands or their FSO to finish the SF-86. Other times I see people that have to fill out and admit to certain financial indebtedness, but they don't have a credit report in front of them, so they miss this information. My staff knows how to overcome those allegations. So those are some of the factors in mitigation. Let's take a look at what the government believes could mitigate or lessen. And that brings us to paragraph 17A. The individuals have made prompt good faith efforts to correct. The refusal to cooperate or conceal was caused by legal counsel. I have so many clients that choose the wrong lawyer. They go to an attorney that is a friend, or maybe he's a divorce lawyer, or maybe he says on his webpage he's done dozens of cases, but in fact that's not true. And so that lawyer prepares documents that are actually harmful to your case. Or you have a lawyer that advises you how to behave in another piece of litigation, and that advice was erroneous, and now the government has raised it in a SOR. The other area that I frequently see is criminal conduct, but instead of going under the criminal conduct guideline, the government raises it under Guideline E, personal conduct. And to repeat, why is the government doing that? Because it's easier for them to prove. So if you get charged with something in a criminal case, but it's dismissed, you'll still see it in a Guideline E allegation, but you won't see it under the guideline for criminal conduct. So these are just a few of the items that I want to share with you. I appreciate your phone calls. I want you to call. I want you to email me at aedmunds@allenedmunds.com. Our law firm is here to assist you and serve you, and we enjoy winning. So let us help save your career and save your clearance. Thank you.